conducting the service. And in the court, it's the same thing. They are all temples. You are in a temple. So you don't do anything that will take away your mind from what is being conducted. Wait, okay. Lanesuk, you didn't call your matter. You people should know that his own matter will come. Okay, because they have a witness by Zoom. Sorry. Yeah, yes. Our apologies. This one, they are taking a witness by Zoom, and our Zoom is controlled at the headquarters. They allocate time to us, so we have to utilize it. So our apologies, please. Thank you. You're welcome. Okay, your witness is on Zoom. Yes, Hamadi, are you ready?
The court awarded 4% of their the law of the claimant is not paid. The claimant does not have right of the court.
Wait first now. I'm writing handwritten note. Claimant does not have right of audience before the court. Authority. Your authority for saying so. You say what? Fine. Now, when you knew that you were going to raise this objection, that rule of court should be in your head, even without you opening it. You should have committed it to your memory already. He says what? Order. Okay. You said the order was made on 2023, 2022. Cost of 20,000 naira in favor of the defendant to be paid before the next adjourned date. For the next adjourned date or Order 38, Rule 4 shall be invoked. Well, it's Order 38, Rule 4. I have always known but it is interesting to know that it is repeated in Order 55, Room 6. But I thought you should have remembered on that day it was Order 38, Rule 4 that I. Yes, yes, that one is recorded. Then you were saying something more. Yes.
The trial was to all documents of the claimant are being admitted. I don't know how to work out. So we have a
that is something you people have settled before we agreed that it will be by Zoom. That is something you people should have settled before now. That is a matter you people should have settled before now. I think it was at the point that you applied that it be by Zoom.
Yes.
Claimant Counsel. It was at the point you applied that it be by Zoom. Isn't it? Is that correct? Hi. Too much grammar spoils a lot of things. I simply asked him, I said it was at a point you asked that it be had by Zoom. It's a simple yes or no answer, and you are now explaining grammar. Yes, it's okay, isn't it? So when you apply that it be by Zoom, did they oppose the application? Did I direct that you refile a Zoom compliant process? So when did you file? 10th May 2024. Please, 10th May 2024. Simple. Defense Counsel, have you been served with the process of 10th May 2024? You have it. So what is your complaint now? So what did you, after agreeing that it should be taken by Zoom, then after he has filed a Zoom compliant process, you now have objection? So the court and the other counsel should suffer the consequences of your lack of knowledge? Is that how it is done? No, this is why he had to specially apply that it be had by Zoom. We had to ask the other party. You said no problem. Then I directed that okay, he should refile it a Zoom compliant process. He refiled and served you. You have not pointed out, you have not filed anything to oppose it. Then today, hearing day, you are now saying that you are made to understand that all documents are deemed admitted and you have objection. And who said that you cannot object? Who said you cannot? What are the grounds of the objections? Mm. Mm. The rule is that even though it is standard, is there any rule that says you cannot address the court and ask the court to expunge it and give you a reason? Is that not how it is usually done? You will, in your address, ask the court to expunge what is already admitted on the ground that this and that, isn't it? So that cannot stop us. Okay, I have even helped you without sharing in your consultation fees. it does not stop you from raising any objection, except if your objection is with the physical document in another different way, or you are saying the document does not exist, or things like that. But if it is because they didn't certify or this and that, you can always ask the court to expunge it. It's never too late. Yes. Yes. Is that your headache again? You can produce the handbook, or you can leave it and then they bear the legal consequence of not producing the employer's handbook. You cannot force them to produce any evidence, can you? Fine. So if you are defense on the handbook, it is your duty to produce the handbook, not him. If he fails to produce the handbook, and by that fact alone, it affects his case negatively, it is his headache. But if you feel that even without the handbook, he has proved his case, if you don't rebut it and you need the handbook to rebut it, then you bring the handbook. It's as simple as that. Yes. So, yes, cost. Cost was awarded, and let me even check on that date whether you were not a counsel in court. What date did you say? Yes, 24th March 2022, and I read it. So, claimant present, defendant absent. Appearances: A.D. Ahmed for the claimant, E. Udofort with L.E. Udofort, and P.O. Amadi for the defendants. You know A.D. Ahmed? Okay. She has changed. Yes, the claimant has changed counsel. No. I say the claimant has changed counsel. Okay. So on that date, I awarded cost of 20,000, and with a specific order that it should be paid on the next adjourned date. And if it is not paid, the court will invoke Order 38, Rule 4. Can you read your Order 38, Rule 4? You don't have the rule of court. Oh, Jesus. You came for hearing. You have a witness ready for hearing, and you did not come with rules of court. What is Prince of Price? Forget about what she's raising. How could you come to court for a hearing without rules of court? And you are calling it a surprise? Wow. That is a surprising surprise. I'm surprised that you call it a surprise. You know that any proceedings conducted in court at any moment, at any point of time, rules of court can become relevant. Evidence Act can become relevant. Constitution can become relevant. And because this is labor law, Labor Act can become relevant at any moment of the hearing. So you are supposed to come to court with all those things. That is what tells us that you are prepared for hearing. Let us not make light of this profession. We don't have any other profession apart from this one. And our aim is to become generals in our field of endeavors. We can't become generals doing our work as if we are just Abba. From day one, when I was a pupil lawyer, in fact, while serving NYSC, I already acquired Constitution, Evidence Act, and all those things. And I never went to court without them for one day. For one day. I never said, this matter is just for adjournment or this, and then I don't carry. We used to have a back these bags that Sans used to carry. We used to have all those books are permanently there, just like you see them here. They are always on my table. These ones, those books were always permanently in that bag. Rules of courts, both the area court, the magistrate court, and the acts, then evidence acts, they were always there. Because you never know from which angle any cancer will take you up. Anywhere, anyhow it takes you up, you are equipped. And we don't just carry them there, we always study them. We had a habit of reading those things the way we were reading our Bible, because we were told that in court, those were the Bibles of the court. So we formed the habit of, okay, we go to church every Sunday, but during the week, we always read the Bible every day. So also we were studying those acts every day. That is how you make a good journey to become something in that field. Please don't come to court next time without rules of court or without constitution, particularly one that contains the third alteration and evidence act. At least these three basic are the minimum. You see, the thing is, okay, read Order 38, Rule 4.
What need order that the party is bad, speaking in order part is good, and after order not being.
Okay, and I read the order I already made on that day. You heard it, right? I said it should be paid on or before the next adjourned date, or this order shall be invoked. That was what I read, isn't it? Or you want me to read again? Good. So okay, let's go to Order 55, Rule 6. Read Order 55, Rule 6. It says, where the court orders cost to be paid or security to be given for cost by any party, the court may order all proceedings by or on behalf of that party in the same suit or proceedings to be stayed until the costs are paid or security given accordingly, but the order shall not supersede the use of any other lawful method of enforcing payment. So by this order, even as I invoke the order, this order is saying it does not stop her from enforcing that cost. She can still take steps to enforce the cost in spite of the court. Anyway, so what do you say now? She said you are in contempt of court, so you have no right of audience based on the order of that day. What is your response? Did she say you are facing contempt proceedings? She said what she means, that act of not paying despite the order of the court is contemptuous of the court order. Maybe I put it that way for you. That act of not paying up to now is contemptuous of the court. And so for that, based on the order of the court, you have no right of audience to be heard. So what's your response? You said the order was made on what day? March. Which date?
The other one was here, they was like, for the pain of how go, scholarship.
On what date?
That's why. So they are not for me to come to
22nd. Because I have here, okay, 22nd January. I was looking at 20th March, where you applied for cost and withdrew the application.
second January.
But application granted as paid, cost of 20,000 awarded against the claimant to be paid on or before the next adjournment. And it's A.O. Ajayi with R.O. Bolajoko for the claimant on that day. So if you claim you didn't know about the first one, what about this one? So it means the former counsel did not advise the claimant, and you too, you did not advise. Orders of court are not made for the sake of making. I hereby invoke Order 38, Rule 4 of the Rules of Court in keeping with the Order of Court made on 24th March 2022 and refuse to hear the claimant today until the two costs of 20,000 naira each awarded on 24th March 2022 and 22nd January 2024 are paid. Yes, claimant, what did you want to say?
Yes, sir. There is no cost awarded that I haven't paid. In fact, the last one, it was when Barrister Ayenake, the first day he took over my matter, and Barrister Udofort, right there. And Barrister Ayenake said right there in the court, he would transfer to Barrister Udofort, which immediately after the court, I made the transfer to Barrister Ayenake. There is no cost that I haven't. If the previous one,
The two costs.
Yeah,
the
yes,
two costs.
Yes, sir. There were about two. There were about 2 or 3. I did, sir. That can be confirmed. Let
me record you.
Yes, sir.
I have paid all the costs through your counsel.
Yes, sir.
It was your counsel that made the transfer or you?
It was my counsel because I don't have the details of. I was not dealing directly with.
Through your counsel, which of your counsel?
The last one was through Barrister Yenake.
Barrister Yenakin was your counsel?
That was the last when the cost was awarded against me. Barrister
He was your counsel?
Yes, the last one. The last.
Yes.
Yes, sir.
Barrister Ayenakin. And who? Who is the other lawyer?
Olomu. Barrister Olomu. Barrister Olomu.
The payment was made to who?
To Barrister Udofort.
That is an interference. Is it Mrs. Udofort or Mr. Udofort?
Mr. Udofort.
Is the male Udofort, not the female Udofort?
Yes, sir.
Okay.
Yes, sir.
Okay. It will be sorted out at the next adjourned date.
Yes, sir.
Luckily, the counsel raising this objection is from Barrister Udofort's chambers. Is that correct? She's from the same chamber, so she can be able to confirm. She will. I have recorded you. I've put you on record.
Yes, sir.
You heard him, right? Yes. Don't worry, please. Please. I have already ruled and we are taking a date. It's for you to know that he said these things were made through Barrister Yenakin and Barrister, is it Olomu?
Olomu, yes, sir.
Yeah, that they made the transfer to Udofort male.
Yes.
I know Udofort female can contact Udofort male to confirm. Don't worry. Go and confirm in chambers. When we come back, maybe Udofort female will come, isn't it? This allegation, and he can try to get proof of the transaction from your lawyer.
Yes, sir. I'll try.
Try to get proof of that transaction from the two lawyers.
Yes, sir.
They can give you proof of that transaction.
Yes, sir.
Then you give it to your present lawyer.
Yes, sir.
Okay?
Yes, sir.
Eh? No, his lawyers who okay, is the Olomo is from Ayenakin's chambers.
No. Sir Olomu was the lawyer that started the whole journey. So, but
yes, he's in the same chambers with Ayenakin.
No.
So why are you people saying? Oh, Ajayi is in the same chambers with Ayenakin, and he's not even aware. So fine. Yes. Okay, so you people can do that. So you people can do that. I'm not putting that one on record. Okay, or you want it on record? To pay the 40,000? The 40,000. So that if you had earlier paid any, then you recover it from them? Okay. Let me record you, Ajayi. But I have already ruled. Anyway, I can overrule myself. But any objection, Amadi? Amadi, no objection. He stood down for 30 minutes. Okay, you will still continue online for 30 minutes or more. That's the sound case. So I will stop my video.